NBC legal analyst Lisa Bloom, former Florida Circuit Court Judge Alex Ferrer, and criminal defense attorney Joseph Haynes Davis. For the three of you and everyone else, I want to take a look at that exchange earlier in which Judge Nelson questioned George Zimmerman about whether he wanted to testify and the back and forth between defense attorney Don West and the judge.
Mr. Zimmerman, have you made a decision as to whether or not you want to testify in this case?
No, not at this time.
Okay, and when is it that how long do you think you need before you make that decision?
May we have an opportunity to speak? The case isn't concluded yet.
I understand that, and I've asked Mr. Zimmerman if he needed more time to talk to his attorneys, and if he does, I will afford it to him. Mr. Zimmerman, how much more time do you think you're going to need to discuss this with your attorneys?
I assume it would depend on how long the recesses are, At the end of the day.
Okay, well, if your attorneys have finished with 2 witnesses before the end of the day, do you think that you would then know whether or not you want to testify?
On Mr. Zimmerman's behalf, that decision...
I am asking your client questions. Please, Mr. West.
I object to the court inquiring of Mr. Zimmerman as to his decision about whether or not to testify.
Your objection is overruled.
Judge Alex Ferrer, you have been in that position of advising a defendant of their Fifth Amendment right. I want you to read those tea leaves. What was going on there?
There is an underlying current of friction between the two of them. Clearly, it's been present throughout the entire case, and it just bubbled to the surface today like it has on other occasions. The judge doesn't need to know right now. There's still 2 witnesses left. He can wait and make his decision at the end of the 2 witnesses. But by the same token, Mr. West really didn't have to make a point of it, because even if he said, I don't really think I want to testify right now, he could change his mind, and later on after 2 witnesses I changed my mind. So it doesn't really matter. It's just, it seems like each one of them was playing on a power play against the other, and it just bubbled up.
Joseph Haynes Davis, I watched that and I said to myself, if and when George Zimmerman writes his book, the story I expect to hear is that he wanted to take the stand and his lawyers didn't want him to do so, and we just saw a representation of that. How did you read that moment?
Well, I read the moment, Counselor, and thank you for having me, as Judge Nelson saying, look, this is my courtroom, and pardon me for using some vernacular, I'm not playing with you. I mean, she's in charge of the courtroom. I've practiced in front of Judge Nelson periodically a couple of times. She's a very, very good judge. She's a very, very honorable judge. And she's a very, very smart judge in terms of knowing where she wants to go and how she wants to conduct that courtroom. And I think in that instance, it was Judge Nelson saying, look, this is my courtroom, this is how I'm going to conduct it. I understand your client's Fifth and Sixth Amendment rights. I'm not going to trample over those rights, but I am going to conduct this courtroom the way I'm going to do it, and you just need to sit there and let me do it because I am going to do my job.
Lisa Bloom, help me get into George Zimmerman's head if you can. I mean, I find it very hard to believe that with 90% of the defense case in, he still doesn't know whether he wants to or is going to take the stand?
Well, it's possible. Look, he hasn't had a lot of time to talk to his attorneys because they've been fighting this case yesterday until 10 p.m., and he's got a curfew. He has to go back home. In fact, his curfew had to be extended last night. If I can defend Don West for a moment, who I think is also an outstanding attorney, I think he's an honorable person. He's not a potted plant. He's there to fight for his client, and he's essentially trying to say, you know what? It's too early. Don't put my client on the spot like this in front of the national media. He shouldn't have to answer this question until the final witness for the defense is called, so don't put him on the spot. I mean, that's what Don West was trying to say.
Hey, Judge Alex, this Dennis Root who testified today, the defense expert, and I've got to believe because they couldn't get the animation video in as evidence, they tried to get in through him what they wanted. I don't, you know, you're the judge, I've tried cases, it just seemed to me like he went way beyond the bounds of what I would expect to hear from an expert. Were there aspects of his testimony that you found yourself saying that's really not something you'd look to an expert to answer?
Absolutely. He was allowed to testify about all kinds of things. Yeah. He got into the psychology. Some of the things he got into, the prosecution frankly didn't object. They just sat back and let the questions be asked. Leading questions, questions beyond his expertise, non-responsive questions where he continued, they would ask him one question and he would expand into entire areas. Some of the questions they did object to and Judge Nelson allowed it in, but basically they fought and fought to keep out the animation, and then they ended up doing a reenactment with a dummy in front of the jury and allowed the defense to do the same. I'm not really sure why they were so lenient on this witness.
Mr. Davis, how could he speak to the physicality of Trayvon Martin versus George Zimmerman and who was in shape and who wasn't in shape and so forth, essentially saying who would have had the upper hand in a fight like this?
I tend to agree with you. I mean, that to me is not very possible, but I think that this jury will be able to put that in perspective and weigh it when they go into their deliberations. I agree with you that you know, it was a bit peculiar with the testimony of Mr. Root and his scope of his testimony and so forth. But I think that this jury will be able to see through that and see and tell that, listen, the deceased victim cannot testify himself and say who was the stronger individual.
Lisa Bloom, you have been talking extensively about the gun position and so forth, and I couldn't wait to ask you about this. Assistant State Prosecutor John Guy used a mannequin to reenact the encounter between George Zimmerman and Trayvon Martin. Let's watch this.
If this person, this mannequin, were carrying a firearm on their waist, where would the gun be right now in relation to me?
Would be at your left inner thigh.
Right here, right?
Yes. If he was right-handed, it would be at your left inner thigh. Yes, sir.
Right. Underneath my leg.
Yes, inside your leg.
Okay. Were you aware that the defendant described to his best friend that when he slid down, the defendant slid down, that Trayvon Martin was up around his armpits? Were you aware of that?
No, I've not heard that. No, sir.
Okay. Well, where would the gun be now?
Now the gun would be behind your left leg.
Okay.
Lisa Bloom, you told me on Monday night on Hardball that you'd gone back and reread aspects of this case and that you thought something had been overlooked thus far by the prosecution. And when I saw that today, I said, this is what Lisa was talking about.
Yeah, I know. I was hoping that John Guy was going to do it in the courtroom today, but he didn't. On the reenactment video, when George Zimmerman is asked where he holstered the gun, he demonstrates apparently reaching back behind his right hip to his back side. Okay, so this witness had it wrong, and the prosecution was not able to correct that because they apparently are not aware, at least so far, unless they're saving us for a big moment in closing argument, that George Zimmerman had the gun holstered not only inside his pants, covered by a shirt and a jacket, but on the back side of his hip. That's where he demonstrates on the video with his hand that it was. I want to say something else about the mannequin. I don't like the fact that the prosecution is really conceding the defense version of the case. We have the prosecution on top of the mannequin, just like the defense attorney did. They didn't use the mannequin. I would have had it standing up, because that is one theory of how this fight happened and when the shooting could have happened. I would have had George Zimmerman on top, as a number of witnesses had him, and Trayvon Martin on the bottom. I would have had it moving it around in a dynamic situation. I mean, to just do it the same way the defense did, I think gives the jury the impression that everybody's now on the same page, that at the time that the bullet was shot, George Zimmerman was on the bottom, Trayvon Martin was on the top.
Well, Joseph Haynes Davis, to Lisa's point, I have been surprised at just how much of George Zimmerman's version has been able to come into evidence in this case. Now, I recognize he gave police statements and a reenactment, but truly, for what purpose would he have testified? Because his version of events has so clearly been put in the record as the example she just illustrated.
I think Ms. Bloom is correct in that it is a little bit interesting, to say the least, that there was nothing being distinguished by the state's turn with the mannequin. And, Counselor, you are absolutely correct. Listen, George Zimmerman has testified, so to speak, by the statements that have been played over and over again with his interviews, with the Sean Hannity interview, I should say, and much, much more. So he has no reason to testify at all as to whether or not he really thought about it when he didn't know what to say when the judge asked him. Well, we will never know that, because we will never know that.
Closing arguments tomorrow. Thank you so much, Lisa Bloom, Joseph Haynes Davis, Judge Alex Ferrer. Coming up, remember